Hi, everyone, and welcome to another exciting episode of Voice of Crypto. And today we have with us Mr. Navodaya Singh Rajpurohit, who is a cryptocurrency lawyer and as well as a blockchain lawyer. He is the founder of Pravadati Legal, and he's also a legal partner at Coinique Consultancy. He has an immense experience in the law regulatory aspect of the cryptocurrency, blockchain, and Web3 arena. Hi, Mr. Navodaya. We're really happy and glad to have you on Voice of Crypto podcast today.
Hi, Varuni. Thank you. Thank you for inviting me here. I have heard a lot of things about Voice of Crypto and I hope it goes way beyond where most of journalism are going on. And I've seen a lot of your content which only focuses on the material and the merits of the matters and not on different kind of thing which is going on in different aspects which nobody actually should bother about, but that becomes a major issue in all the YouTube videos and journalism. So great work, Voice of Crypto, and I'm grateful for you calling me here and being here as well.
Thank you so much, and we continue to keep doing this same work and be the voice of crypto in this industry. And while I gave a brief introduction about you, can you please tell our viewers a little more about yourself? What sort of cases have you handled, and what are you doing currently? What are you up to?
Sure. So I've been practicing since 2014, and during my work on different kinds of laws, I've worked on litigation aspects. I've worked on VC. I've worked on insolvency. I've worked on competition matters. But recently, around 2020, I started working on cryptocurrency and blockchain. I started reading up more on that. In fact, I actually read the first Bitcoin paper in 2010 or 11 somewhere, but I couldn't make out as in what. So during that time, we used to write a lot of articles because that used to help our CV and to get job. But since I could not understand what Mr. Satoshi or a group of people were trying to say, I left the paper there then and there itself. But recently, when I realized that was the paper, so I read through that again. But then I started working on blockchain, and since I lost some money during my initial investment, and there was no lawyer who was actually working in blockchain industry in India, so I thought, why should not help myself and then start working on it? So since 2020, I've started working on blockchain cryptocurrency and met a lot of people, a lot of good people who are actually trying to change how financial system is working throughout the world. And it has been a good scent for last 2 years and 2.5 years now.
Sounds great. And now that we finally have a lawyer on our podcast, I think there's one case that has plagued the cryptocurrency industry for a very long time. And it is the Ripple versus SEC case. And we often say that the entire pressure of the industry falls on that one case, especially when it comes to the regulatory aspects of cryptocurrencies and whether they are viewed as securities. What exactly is a security? These are a few questions that we would love for you to shed light on. But before that, I will give a briefer around what exactly is Ripple to our viewers. So Ripple is basically a blockchain-based payment network and a protocol, which also has its own cryptocurrency called XRP. And the Ripple versus XRP case dates back to, I guess, 2020, when SEC, in fact, brought Ripple to the court. Brad Garlinghouse is the founder of Ripple, and he has been in quite deep water after the case. So would you shed a little bit of light on how the case exactly started and what led XRP to this conclusion?
Sure. So very interesting fact which came up during this matter was going on was when some of the documents were released by SEC. After discovery was allowed by the judges, was that in fact Ripple, before they get into XRP and launches token, they had a legal opinion from a law firm in US asking whether they should have XRP as their own tokens or whether they should keep it separate from the entity so that it does not fall under the category of securities. So that at that point of time, they were advised to keep it separate XRP and Ripple separate, and so that it doesn't become a security. And as lawyers do, that all the disclaimers was there with respect to this is only an opinion, should not be considered as the final say. So based on that, Ripple actually changed their whole business model and kept XRP and Ripple separate. Later on to find out that this could also be a security. So what has been happening in Ripple versus SEC is it has taken quite a crucial turn now when almost all the filings are completed. And recent filing, I think, was done on 9th of December. And there have been rumors going on where SEC and Ripple are supposed to meet on 15th of December to decide on a settlement as well. But let's hope it goes for a settlement. Otherwise, if it comes as a judgment, it can go either ways. If it goes in favor of SEC, which there's a recent case which happened, I think LBRY tokens, where LBRY tokens have been defined and designated as a security token, which will have a great impact on this case, because they are actually relying. So the recent filing which they have done, they have relied upon LBRY case, where SEC has won the matter and LBRY has been defined as a security tokens. And this, if that precedent is taken in this matter, then judge might have to go with the already existing case, which is already there.
Right.
If that happens, then the whole crypto industry will suffer, because most of the tokens or most of the cryptocurrency will become a security token, and majority of them are not registered with SEC.
Exactly.
If it goes for a settlement, then there's a aspect which will not affect the market much, but will definitely affect the cost, the prices of Ripple. Because if they go for a settlement, Ripple might accept the fact that this could be a security, but it will not be a precedent which will be used in further cases. But they'll eventually have to pay some amount to SEC for settling the matter.
Got it.
The third scenario which can happen is Ripple winning the matter and deciding that this XRP is not a security, but a cryptocurrency or a commodity, depending on what the judges decide, but certainly not a security token.
Okay.
If that happens, then it's a complete win for Ripple and for the whole industry.
What exactly do you mean by a security in legal terms?
So security for US, it's only based on a specific test which happened.
Howey test, if I'm not wrong.
So that says that has 4 components. First, there has to be investment contract. Secondly, there has to be a common enterprise. Thirdly, people should invest only with the intention of getting some profit or benefits out of that investment without working themselves, only based on the works of the founders or the promoters of the company.
Okay.
If these aspects are fulfilled, then it becomes a security. However, it is a very, very old way to decide whether it's a security or not.
Right.
But let's see how it goes for that, because most of the amicus curiae briefs which have been submitted to the court are saying that this Howey test is way old and cannot be applied on the recent technology, which is blockchain, because maybe there are some aspects which are falling into this, but a wide interpretation of Howey test should be there and should not be a restricted version of it, so that every other thing can be fitted into that. Especially when the Congress is deciding on whether SEC or CFTC should have the jurisdiction over the cryptocurrencies.
Okay.
So when the government itself is not sure whether it's a security or a commodity, how can this be decided by a court? Because ultimately it will be overruled by the Congress at the end of the day.
Right. And what exact criteria of the Howey test does XRP not fulfill?
See, it's a argumentative thing which we have to go through, because if we go for both the parties have submitted reasons why it should be a Howey test enabled or why it does not follow the Howey test. So what Ripple is saying is that they don't have they have not this. First of all, there's no investment contract as such. So people have investment. So people who have invested in XRP don't even know what XRP or Ripple is. So they either know what XRP is, what are their utilities, but they don't know whether Ripple is the owner of XRP or not, or what Ripple actually does or not.
Okay.
There's no investment contract. Secondly, there's no common enterprise which is there. People who are investing are from different different jurisdiction, different places in the world altogether. And there's no specific common enterprise through which everybody is investing in XRP. Thirdly, the primary aspect which everybody is talking about with respect to Ripple is that whether it has been portrayed or marketed by a third party.
Right.
So Ripple has not done any marketing through a third party because it was their own products, so they marketed it through themselves. So according to Ripple, it does not fall into that. Now, what SEC is saying that why it falls into how it is because the moment people are investing in this XRP only with the aspect of gaining more money out of it, and what Ripple has done through various YouTube videos and various conferences and lectures of whatever communication they have done through emails, through publications.
Right.
They have made sure that they have told the public that the Ripple is working towards betterment of XRP, which will eventually rise the price of XRP and the people will benefit out of it. So this is how SEC is saying that people are invested only on the basis of the work to be done by Ripple for increasing the prices of XRP. Right. So that's why they are saying that this is how it is, and this follows the how it is, and that's why it should fall under the securities.
Got it. The fate of the token and its price is very closely linked to the fate of this case. And people have a lot of predictions of post this case, how XRP would pan out, how its price would pan out, which has also led to XRP's pump and dump pretty often. And if you look at that, what do you think? Why do you think XRP and Ripple's fate is tied in those terms? And do you really think that Ripple winning the case would affect XRP's price in, let's say, a drastic or mammoth manner? Or will it just be the same looking at the larger bear market?
See, currently it's roughly below $1. Prices.
Has been for a very long time, in fact.
So court matters does affect the prices of securities or even in India also, if a court matter is pending before Supreme Court, the order favors one company, it's a listed company, then people will go and buy their shares for sure. So that is for certain that if Ripple wins the matter, the prices will go up. But to what predictions I've seen, as in it will reach to $33 is quite far-fetched. But it will certainly go beyond $1, at least maybe $10 also. But relying only on this should not be the criteria for investors to invest, because this is not the final decision. So even if an order comes in from this court, there are chances that the matter will be appealed.
Got it.
And I've seen the documents, and the reason why the decision has been pending for so long is for a reason, because either the judges does not want to define that because they want a higher or appellate court to decide whether it should be a security or not. Or if they decide, then there's always a chance of SEC or Ripple appealing this matter before a higher bench or the appellate court, which will finally go through the whole legal aspect. They won't go for the facts, then what are the facts, but they will certainly go for the law, whether this law will be applicable on the decided facts before the court.
Understood. So while there are rumors that the case might be settled in the first quarter of 2023, are they in fact just rumors, and the case will take in fact a lot more time to get settled or come out clean?
See, for this, we all know that there are documents which prove that 15th of December they will have a meeting for sure. 22nd December has been set as a date where all the submission has to be made by both the party or all the non-party also.
Right.
So by 22nd December, all the submission before court will be done. All the arguments has already been finished. Witness statements already been done. Amicus briefs have already been submitted. So by 22nd, everything will be submitted before the court. So if settlement happens on 15th or before 22nd of December, then the final version will come before 22nd of December. Otherwise, it might take some time for them to decide and finally pass the order. which can go which can be decided in the first quarter of 2023.
2023. Right. And while there are a lot of possibilities as to how this case would pan out, a really interesting idea that Jeremy Hogan recently spoke about at a certain podcast that he went to was that the case would come to a draw. So the first would be that Ripple wins, second would be that SEC wins, and the third alternative could be a draw. What exactly would a draw-like situation be in this case?
So see, so draw is kind of a way where it's a win-win for both the parties.
Right.
So for the claims which SEC is asking and the claims which Ripple has, so currently it's going for a summary judgment. It's not going for a jury trial. So what Ripple has asked earlier was to go for a jury trial to decide whether it will be a security or not. Whereas SEC is asking that it should not be a jury trial, it should be a summary judgment. So the difference between summary judgment and a jury trial is basically, if the judgment is given only based on documents, then it becomes a summary judgment. So everything is available, all the evidence is available on paper. So you can decide on the basis of that. And there is an acceptance of the fact whether there is security or not. So you don't need a witness statements to be cross-examined, or all those things should not be done. So that is summary statement. Whereas in jury trial, what happens is jury is set up from the local people who will listen to the whole arguments of both the parties, all the witnesses, and then decide on whether it should be or it should not be.
Understand.
So if the only draw situation which could happen is a jury trial will be set up, and then this judgment will be delayed further. The whole process will go for a litigation where jury will listen to the whole arguments, and then maybe thereafter they'll decide whether it's security or not. So that is in between situation where nothing is decided, and we only go further with this case.
Right. Can you give us some latest updates from the case? Where exactly, if we look at the timeline of this case, where exactly are we with the Ripple versus SEC case?
We are towards the end of the whole thing now, because it's been going for 2 years, and there have been issues in between where SEC's ex-chairman Hinman's speech was asked for whether it can be produced before the court or not, which ultimately the court allowed. And Ripple is heavily relying on Hinman's speech, because in his speech he has made some comments which are actually beneficial for Ripple to say whether it's security or not. So if everything goes well, by the end of roughly Feb or March, we should get the final order of the judgment. There's no argument. There's nothing left in the matter to be done till the time whether the judge decide whether it should go for jury trial or not. So it's only the final order which has to come. So around roughly 7-8 amicus briefs have been submitted for support of Ripple, and there are around 3 to 4 amicus briefs which have been submitted for or on supporting the SEC's case.
Okay.
So they have a lot of material now to decide on what to rely on.
Right. And if you had to state like 3 or 5 possibilities as to how this case would in fact end according to you, what would be your say? We would also love for you to state them in the same order as you feel the case would pan out.
Depending on the documents and the evidence which has been submitted, I think it should go for in Ripple's favor, because especially because of Hinman's speech. Then there are a lot of documents which proves the fact that this could not be a security, but it cannot be 100% that Ripple will win.
For sure,
because there are evidence against them also, where they have made statements like Ripple is working towards benefit of or making XRP's prices go more. They are trying to they are entering into contracts with most of the banks. They are expanding. So all these things should affect XRP's price, and it is directly related to them. So I think majority of chances, maybe 50-60% chances goes in favor of Ripple. 30-40% chances goes in favor of SEC. But I am certain that whatever the result, if it comes from a court, then it is certainly going to be challenged before a appellate court.
Okay.
Otherwise, the best situation would be to settle the matter. But if you settle the matter today, there are a lot of cases which are pending. So SEC is lining up cases based on this case.
Right.
So if this goes against them, then all the cases which are in line will not come into the picture. So everything is happening simultaneously when the Congress is deciding whether to go with CFTC or SEC with the final jurisdiction over the matters. Then Ripple case is ongoing. LBRI case has already been finalized. I haven't got a chance to see whether the LBRI case was appealed or not. But this case is certainly going to affect both Congress and as in the whole industry altogether. So, right. But in one line, if we have to go for it, it could be a win for the industry.
Yeah.
But we'll have to wait and watch.
So before we wrap, I do think that we have the gist of what the case looks like. But before we wrap it up, can you tell our viewers how exactly will the Ripple versus SEC judgment, if it does pivot towards SEC, affect the larger narrative for cryptocurrencies? And will it have a bad effect? And will the definition of securities change itself?
So see, like what I was saying, so the judgment will apply how we test on this matter. And if this facts fits into how we test, all the other matter which have similar facts will be read in this, and this precedent will be read in that. And therefore, all the tokens which fit into these facts of Ripple versus SEC will become a security token. And all those who have not registered with the SEC will have to pay a hefty fine to the SEC for not registering and selling unregistered securities. Also, this will affect what is already happening in the industry is that most of the new tokens which are being launched are not launched for the US citizens. Because not everybody who is launching token is going to US and registering with SEC because of this case, since the case is pending, and it's pretty evident on the face of it that even if you have an opinion which says that it is not a security, it could become a security if SEC decides it is a security.
Right.
So most of them are keeping away from US market. But if it goes in favor of Ripple, you will see a lot of them moving to US, as in most of the tokens which have already been launched or in the process of being launched, they will be served to US citizens as well. But if it goes in favor of SEC, then we have there is a certainty then. If there is certainty, then you can follow the rules and work according to the regulation which are there. But if the certainty is not there and everything is in limbo, then it becomes an issue for the promoters as well, for the lawyers as well, to decide whether it will become a security or it will not become a security. And that's the reason why most of the companies which are launching tokens in US, they are going forward and registering themselves with SEC to not have a headache at a later point in time and then be told that this is a security and you have not registered it. So we will see a lot of change in market strength also, because once the companies are registered in US and the tokens are launched in US, there will be a free fund of free flow of the funds from VC and angel investor as well.
Got it. Off the top of your head, can you name a few companies and their tokens that might have to face a similar problem once the case does go on SEC's side and Ripple loses?
See, what current SEC chairman has said is that apart from Bitcoin and Ethereum, everything is a security token.
Okay.
So we can't judge which will be or which will not be, but according to SEC, everything is security token. Apart from Bitcoin, they cannot recognize as a security token because there is no one behind that. Ethereum can also not be decided as a security token. Why? Because they are working completely on a different tangent. Then comes all the other token and even in the agreements also, most of the lawyers have mentioned that this is a security. We are selling you a security. And if you are mentioning in your agreement itself that it is a security, it becomes security because you are admitting that fact. So this
yourself.
So if you are admitting things, then you don't have to prove anything. That's why the summary judgment goes for that.
So this could mean that the larger cryptocurrency market can face a major shakedown if the case does not fall in favor of Ripple. While we, being inside the sector, do hope that the best happens for the market, what in fact will happen is something that I guess only time will tell. But until then, we have a lot of predictions. We have all sorts of price predictions for XRP, and there are a lot of lawyers who say that the case might tip on either side of the judgment. Before we wrap, once again, can you say I am the voice of crypto, because we do this with all our guests. And since you, being in this space, are an essential voice of the sector, we would love for you to say that once for our audience.
I am the voice of crypto. I think everybody is a voice of crypto who are in the industry now. And the major issue in India is that nobody is raising their voice for crypto. So everybody has to become a voice of crypto and then maybe collaboratively discuss with government and maybe come up with a regulation in India as well.
Well, this was a really insightful session, Navodaya, and we'll be back with another session for our audience, because clearly there's only so much we can cover in one episode. But we'll come up with a lot of exciting cases, I'm sure, and with so much happening in terms of regulations and taxation, I'm sure that you would have a lot to add. But for today, this was a really insightful session, not just for our audience, but for me as well. There were quite a few pointers that you touched upon, decoding the Howey's test, what exactly is a security, and a lot more. And we hope that we are able to have you again on our podcast.
Thank you. Thank you so much, Varuni. Thank you, VOC, for having me here. And it was a great session. Hopefully, we can learn a lot from you and from the people who are going to see the final podcast. And if you have any questions, then I'll be happy to answer that.
Definitely. Do you have any final closing thoughts before we wrap it up?
We're all fingers crossed for Ripple. Let's see how it works out.
Right. Really interesting and fun session with Navodaya here today. For more such content around Web3, blockchain, and cryptocurrencies, stay tuned to Voice of Crypto.